Excellent. Welcome. We've got a lovely presentation today from Arnela Tolic. It's going to be talking with us, ideally not talking at us, so feel free to engage, ask questions and participate as much as feels appropriate for you. If you're somewhere where you're not able to turn on your microphone, feel free to use the chat as well. And we should have a really good discussion on equitable division of properties. Arnela, are you prepared to just introduce yourself a little bit at the start of the presentation?
Oh, absolutely. Thank you, Joanne, for obviously having me here today. It's obviously lovely to see so much interest in this very interesting topic when it comes to equitable division and family property mediation. A little bit about myself. I'm a legal practitioner and have been for quite many years. And what sparked my interest is really look at how we best can mediate some of these certain conflicts that do arise, particularly in family property itself. What I like to do is make sure that I get parties engaged. And like always, even with this particular session, please do drop anything in the chat box if you have any questions. I'd love to get you engaged and any feedback and comments about this. What I'd like to perhaps also take you through is a way of having parties participate in mediation and the benefits of that, as opposed to perhaps running straight to litigation itself. So without further delay, perhaps we might get started, Joanne, with the session for today. I will make sure that you do get a copy of these particular slides and you may want to refer to them. And if you have any question, feel free obviously to reach out to myself. I apologize if I sound a little bit coming down with the cold. It's a little bit of a colder side here in Sydney. I'll do my best to get you through this particular hour. I had to find an image to get started, and it's really to do with families and families going through a difficult time of separation and really understanding how they can work through mediation as opposed to litigation in really looking and overcoming some of the challenges. So what I'd like to take you through is some mediation strategies, particularly for property matters, some of the factors that may be influencing, obviously, mediation, and this only refers to property, so not parenting in any case. I'd like to also take you through some of the high conflict personality traits and our role as a mediator of how to work with some of these particular individuals if you are working in the scope as a mediator itself. There are going to be some common challenges as part of that itself and really managing some of these emotions and really getting parties to engage in that effective communication in that mediation. Now, as always, if you do have any questions, please do feel free to ask as part of this session. When we start off with mediation, when we think about parties participating in mediation, it is obviously wanting parties to sit down and engage in that discussion. And we find in family law in particular, when it comes to property and the division of property, there is often that high conflict that arises as a result of that. Now, we do have parties that participate that are certainly very calm at the beginning of the process, who then obviously throughout the process may turn in what we like to call the high conflict personalities. What I am not here to do today is to obviously talk about the legal impacts and the processes in the legal structure itself. But what I'd like to put your attention to is that the court itself and the family court does require parties to participate in mediation at the first instance before they obviously proceed to any legal proceedings from there. So how do we then manage clients who want to adopt that because it's obviously given to them that they have to participate in that? And how do we manage their emotions? Because it is often these emotions that we as mediators need to be able to control. You'll find that individuals who participate in mediation, and that is to do with property, there's often quite a lot on their mind. It could be from real estate that they want to obviously get resolved, that they like to work through, personal properties, it could be vehicles, furniture, jewelry. It is not a complete list on these slides. Then you have parties who even have investments, debts, and even other financial, obviously, resources that they want to talk about and find a common ground of some potential, agreement. Now, what's really important to remember is that we are not here to find an agreement for parties, but more help them facilitate in that particular process. So how do they work through this and how do we maintain ourselves as mediators in finding a common ground of both parties wanting to participate as opposed to maintaining that obviously high conflict? Now, what we are also seeing quite a lot is that idea that the only time that you get an equitable division of property is in court. It doesn't have to be that way. My view to this as a mediator is that parties are more controlled about their own outcomes, as opposed to taking matters to court where you have a judge, an independent party, make a decision about what parties have at stake here and what they've done so far trying to resolve that particular dispute. Again, it could be as far as narrowing down some of the questions and queries that they have, and really making sure that we have the dynamic and that balanced dynamic between the two parties that are participating in mediations. It often is one of the situations where we really need to understand what type of mediation process do we want to have parties participate in. So there may be different techniques that you may want to adopt. Shuttle mediation, very common in these processes. Often there are obviously options where parties can also be participating in person. Now, in terms of some of the effective strategies, there may be quite a number of ways where we can hold the dynamic and holding that balance when parties are engaged in mediation. And that means how they can actively participate in that process and make it worthwhile, obviously, for their time in participating in that process. So what you are going to hopefully gain at the end of this, alongside with the rest of the colleagues, is to really understand some of the ways that we can navigate through property division, through mediation, and facilitate that smoother process and more successful outcomes. Now, I may put a disclaimer in there that we are not to find an outcome for clients. We are really there to help them to facilitate that on their own. So really guiding them through that process and helping them in some possible ways to find that common ground. Now, you may, as family practitioners, if you are out there, or as mediators, often come across, obviously, some of the common challenges and disputes. And there may be disputes where parties have engaged in some legal process so far, and they've been advised by their advisors, legal advisors, to participate in mediation on the forefront. And they may have disagreements about the valuations. They may have disagreements about fluctuating market conditions and what is worth to them. Or they may be simply saying that something is, such as assets, such as antiques or collectibles, any other intellectual property that is of a certain worth, and they may not agree on that particular opinion. So there could be various ways that obviously some of the common challenges are raised about what certain property is worth and how to best to obviously work through that. Now, in terms of some of the complexity that we see quite a lot in mediation is really the dispute about contributions. And if you are coming from a particularly legal background, there are obviously different ways of how the contribution is to be assessed. Our role is not to assess that contribution, but be mindful about what the parties are telling us about what the issues are and how they're best obviously looking to work through this. So there may be obviously looking at what is the property pool, what are the contributions that have engaged so far, any future needs, as we know that's outlined by law, and then any just and equitable outcome. And the hardest part in our position as mediators is really maintaining that neutrality. So we want to make sure that obviously parties have an opportunity to identify what it is that they want to speak about in mediation. So are there any particular things that they want to raise? And that may be to do with property. It may be to do with certain other commingled assets or any disputed contributions. What we should not be really engaging in is to really identify what has taken place in the past and how that may impact that particular discussion that they're raising today. Now, we would obviously have some other strategies to address this. It may be that they need further documentation about tracing back the origins of certain assets. And I'm giving you this as a more of a forefront of what really is taken into account as part of these mediations itself. We are not parties that obviously can do professional appraisals, so we may consider where parties may, obviously, if they don't agree on certain aspects, engage in getting some certain further advice and obviously on getting on these particular valuations of certain properties or any other part of that particular property division. What we see, and I'd like to get your feedback and I guess maybe your comments on this, but with a lot of the family property mediation, you find a lot of legal practitioners putting together a bundle of documents, a bit of like discovery that they've done so far, and that is sent to the mediator. While the mediator is not bound to take that into account as part of the process, it's important that they appreciate and I guess confirm that they received that correspondence and that they've acknowledged reading that. So really important that we are mindful about when parties are reaching out to us and seeking our assistance, and if they have sent something through from the legal advisors, to what extent, obviously, we consider that as part of mediation itself. So I've said quite a fair bit, obviously, to get you thinking about some of the impacts that may be there and some of the challenges. And I do see that there is about perhaps 2 comments on here or 2 questions. So I may take a look at these questions, and perhaps I guess it's a welcome that I see here from Joanne and Rana. If anyone has any questions, do feel free to ask, obviously, in the chat box, or maybe through obviously using your microphones to ask any questions before we go into identifying high conflict personalities and how to really manage that conversation. Does anyone have any questions?
I'll ask a question. Oh, should I put up my hand?
That's okay. Go ahead.
How do inheritances work?
Okay, so inheritance, I guess if you are going to consider inheritance as part of the property pool, that really comes down to whether that inheritance obviously is something that is included in the property pool, which generally does get included in that, and whether that already has been distributed, at what point that inheritance has been provided to that individual. But you do see that inheritance, and that's a good point you raised, is also included as part of this, because it may be something that the person received at the beginning of their relationship or throughout the relationship. And obviously, as long as they have received that, it is something that generally gets included, obviously, as part of the property pool. And it's a difficult one, because inheritance is obviously provided to one party, but then because they are obviously in that relationship, and it forms part of that pool that they are going to include it as part of. And there are some particular provisions given if you look at the Family Law Act there. When it comes to mediation, it comes down to the point of how do we address that? And it is something that I guess parties would need to work through as to whether that particular inheritance that was received forms a major part of that particular property pool. So there may be other contributions that they've made besides that, or any other financial position that they're in besides just that inheritance itself.
Yeah.
So hopefully, maybe I've addressed your question.
Yeah, and it would be normally considered as one of the considerations if it's already been absorbed into the property pool or spent on holidays and things as well, wouldn't it?
Absolutely. Where a person received that inheritance as part of their being in that relationship, it forms part of that asset, and what they have done with that particular money itself, whether they use that money to, let's say, put it down for a deposit of a property, whether they purchase something to improve a property, whether they've obviously gone on holidays, whether they spend it on something as part of their relationship. So certainly it is, as obviously Joanne mentioned, part of these considerations that obviously we would need to work through that. And look, a lot of the times I find that it is one of those perhaps not as major components of consideration. It's generally where you find, obviously, through more larger components being properties, certain shares or certain tangible assets that they have, and where they obviously have gone up in value, where that dispute often arises of what that is worth and what that person's obviously share of that particular asset is. So again, I welcome any other questions that you may have on that.
Yes. Oh, did you have anything following up on that? Or there was a question in there as well, or just a comment about the importance of gaining approval from clients if you're going to speak to third parties. I think that might have been related to referrer or valuers and.
Oh, absolutely. And thank you for that. If you are going to obviously have parties participate in mediation, and where you find that the dispute relates to appraisals or valuations, you may want to suggest to parties to get their own independent, obviously, legal advice and reference to further appraisals. It is not for the mediator to provide advice, more information, that this is something that they should gain access to, if that is the ultimate part that stops them in reaching an agreement. So they may have to obviously go and do that and then come back for perhaps a further session. So it's not something that the mediator can get involved by way of advising someone, go to this ABC and get a valuation from there. It's more about saying that valuation may be necessary. And what I'm hearing from both parties, that this is one of those, this is the key element of your dispute, and perhaps having that completed first and coming back and then trying to find a common agreement in some way where possible. So again, thank you for that important point that you raised there.
Yeah, and just before you proceed, Elena's got a question about disclosure, particularly around bank accounts, because sometimes people might be very interested in what they've been spending money on. And
yes.
Is it okay just to provide the totals or values or things like that? So.
When it comes to disclosure, I guess one of the key things here is that full and frank disclosure is required. Now, you may have situations where you may have to assess risk element there, where parties may want to retract certain information on that bank statement for safety reasons or concerns. That is certainly still be valid, but parties would need to provide some kind of balance of what they hold in their own names when it comes to bank balances. If there are any safety concerns, and I've seen that in the past with clients where there may be domestic violence, family violence, or some other concerns that may be there obviously is a plausible reason why they would retract some of the information about where things have been spent, because that may identify locations and movements of certain parties. So you could still rely on the balance. I don't see as much, and again, I welcome your feedback on that. I don't see as much about wanting to know where the money is spent, so much more about what do you hold in your name and what is the actual current balance that you have at the time when you come to mediation. You may have obviously high conflict parties, and we'll come to that, where personalities, I should say, who would want to know that. And that's where we need to reach that control of why they're here today. Not so much to want to know the nitty-gritty of where the money has been spent, about more to do of how do we focus on the future and the tasks that need to be attended to. And that is, how do we find the common ground in resolving these agenda items that are raised, whether it's a property that I have, whether it's any other assets, bank balances, investments, any type of things that they obviously raise themselves as being one of the key issues that they don't see eye to eye. And that may be that they receive 3 valuations from the opposing party, and the person who initiated the particular mediation does not agree. So they may want to think about, what else can I do to obviously be able to agree on the valuation of that particular property itself? So it's generally often raising the issue of property and then working obviously through some of the other key things that are there. In terms of how do we manage strategies and how we manage family law property divisions, there's quite a lot obviously involved as part of that. And I often like to start with the middle one first. It is certainly active listening that has to be there. You might have to paraphrase if you find a lot of language that is used in that is not appropriate, and making the party come back to the center of why they're here today, and really doing some reality testing as to what they want and where the long-term implications are. Parties that join obviously to a lot of mediations, particularly in family law, are emotional, and they've had quite a lot happening in their own background, living their life while having to deal with obviously this component in their life. So really making sure that we manage these emotions and that we acknowledge the feelings, but not dwell too much into that, where it may be a defensiveness that may be raised. And you might not get any kind of valuable contribution by either of these parties obviously participating. If you see that it's not really working out, you might want to take a break. Fresh air does help quite a fair bit at times, where parties may get a fresh mind and coming back to that. And if we are looking at some of the other roadblocks that we come across, and I guess then if we have this situation, it goes back to highlighting the common goals. And often they have quite a lot in common, and that is they want to resolve, be able to move on with life, and they have certain things that they agree on, and it may be small particulars where they simply don't find the consensus. And I can give you one example where I have seen clients participate, and it was to do with a particular bike that was owned, so a motorbike, and what the valuation of that bike was. Every other part of the property pool was agreed on, and it kept going back in circles about what this motorbike was worth. And they had valuations done and who contributed to what extent. Again, while acknowledging how they feel and showing that empathy is really taking them back to, if you are not able to agree on this, what does that mean for you? And really getting their emotions in control as to, we need to really stay focused on the task, and that is the task. What does this bike mean as part of this overall contribution? And I use that as an example because that particular mediation took well over 4 hours to do with just the bike. But having them acknowledge that this is the minor part of that is really the focus where we should be heading them to. And you may have examples of your own clients where they may really focus on the smallest things and then miss the bigger picture of why they are obviously participating in mediation and why they should be really focusing on generating some of the options of how to resolve this, as opposed to being in their way and starting to have that idea of a blaming game. You may not agree with what I say. So again, as mediators, taking the charge and rephrasing of what they are saying to one another without obviously that evolving in some kind of further conflict there. Now, again, this is just some strategies. You may have other ones of your own that you might want to go into detail in. It's really important to have them have an opportunity to talk about why they're participating in the mediation and what brought them there today. And they might tell you, I have to attend because it's mandatory for me to do that. But at the same time, really capturing and actively listening about what they want resolved. They may have 2 key agendas. They may have 3, they may have 4, really bringing that into balance of what is the most important. And the way I like to structure that, it starts with the smallest one first. So whatever is the smallest thing, you start off with that first and leaving some more time to get obviously to the more complex things. Because if we do it the other way around, we find that by the time we get halfway through, parties may be exhausted about such a big element of what they want to discuss and really lose that focus towards the end. Again, I encourage your view and obviously feedback on this itself. Now, as you may all know, if you're in the space of family law, there's obviously the asset pool, the financial contribution, the incomes, the investments, the stay-at-home parent and what they contribute and how much is the non-financial contribution worth, where that forms part in that discussion that takes place, and really capturing obviously the key elements of that effective engagement between the two. And that may be that we would have to identify if somebody is a high conflict personality. And I'll give you obviously some tools that obviously talk about how do we identify this and how do we best de-escalate that situation from becoming something that is completely out of the control of the mediator. And you may not have finding any type of solutions between any of the 2 parties, and they may leave more disgruntled than when they first joined. So really important to identify it, even from the initial component of your intake, and understand obviously what they say to you and what you capture, and prepare yourself, as I always like to say, for the best and for the worst when you obviously have the clients participate on the day. I see there's a lot more questions coming in. I'll take a look at the questions unless, Joanne, you want to obviously read out the questions and I maybe answer them.
Yeah, look, there was one about future needs, asking if you could elaborate more about future needs of the parties. And the other one was really more about, I think, endorsing what you were saying about the importance to really work through with parties about if they're not agreeing about values and batners and whatners and all sorts of things, if the importance of testing so that they don't just rush off to court to try to get a judgment.
Absolutely, and thank you for that question. And one of the elements, again, going back to the legal framework, really without going into the legalities of things, is that future needs. And as part of the property pool, it's part of the considerations there, and really identifying what parties generate as options and where they find themselves. They may be in a shortfall because one party may have a better income than the other, and really having them talk about what that would mean for them. You may have someone who is obviously much better off and has a different position. And I'm just picking that as an example where you have someone who may be working as an engineer, and the other party may be a stay-at-home parent, and what imbalance that obviously is on the forefront being seen. So some of the questions that we can obviously have the parties elaborate on is to really take into account of what that obviously means for them, having been able to have an opportunity to engage in employment, and what they see what the contributions of the other party is. Because again, stay-at-home parents do contribute by way of their improvements towards properties, towards looking after children, towards obviously saving money for certain things that they want to invest in. And I guess it has to be carefully curated, the questions that are put forward about that exploration stage and the future needs. One party may say, my future needs is to engage and have ABC. And the other party, who may be obviously a non-financial contributor, may have different type of needs. So really having them come to that, dissolving that imbalance and getting them to see, obviously, of where the pain points for the both of them are. So you would really want to go into that exploration stage and say, so now that we're looking at ABC assets, and they may raise future needs as an issue, you would want them obviously to openly discuss that. Now, a fine line of that would be really giving legal advice and contributing in advising. And if you find that by the questions that you ask and the effectiveness of your question, that they're not seeing on the same page about what the future needs may be of B, who is a home parent, who might not be able to get a job, going back into the workforce, who may consider that their contribution should be 5% more than obviously what they discussed as generating options there. Again, getting them to elaborate on that more is really imperative. It is a very difficult situation, I must say, that when we are engaged in that mediation process, that we can't really advise parties about what would be their contribution. And some may turn to you and say, what do you think? Or what should I consider as part of that? So that is where we need to advise them to obviously gain some way of legal advice. Now, if someone has an example of that, then again, future needs is one of those elements where it may be anywhere between that 5% difference that they see, or it may be a larger difference. And again, getting them to acknowledge that and explore that as being a vital factor in obviously deciding on this. And perhaps one of the ways getting them to see the other person's view and acknowledge the other person's view is to really have them back focused on the idea that the reason why they're going to mediation is to really save on time and costs. And if they can't find the consensus, then they will have an independent party, obviously, to obviously engage in that process and decide on what the future needs are, which may be a lot different than what they actually saying that the actual future needs are. So you would see that obviously being expelled perhaps out of proportion than what it is initially. So it's all about the language, the way it's curated, and getting them to explore on that and understanding, obviously, that one may be in a better position than the other and putting that forward. What does that mean for them? And how do you respond to A of what they are saying that they feel their future needs are at this? So again, it's not for us to be really driving that discussion, but more in engaging in really carefully, again, I use the word carefully curated question of getting them to explore what that would look like. So hopefully, I'm not sure who asked that question, that answers some way of how you would do that.
Yeah, that sounds good. And Iveta just dropped in a useful little tool for calculating pay and X and all sorts of things. So a couple of just resources dropped in. So I think you can continue on.
And you're absolutely right. There are, I do see on some of these comments here, there are obviously some tools that you can use, obviously, in a pay calculator. You can certainly do that. It's really important to have a bit of a chart of coming to that, obviously, to the mediation of preparation of what they have got so far, where they're sitting at so far, and I guess how they can move forward, coupled with some of these, obviously, individual budgets. And thank you, Iveta, for sharing that. So there are obviously different type of calculators, and to be quite frank, I wanted to engage in showing you some of the examples of calculation, but then I thought everybody might just say there is a lot to calculate here, but happy to share that if you like of what I usually recommend, obviously, parties obviously to use there. So it might be that Money Spot, it might be other obviously tools that are available through the government where you can obviously utilize this to understand your financial future needs and positions there. I guess one of the key parts here when we engage parties is really to have that certain clarity about how this particular mediation is going to work. So we talked about managing emotional dynamics and emotional awareness, and obviously how do we best work with individuals, including de-escalation techniques. So you may be reframing from negative comments, taking breaks, and looking at the neutrality that has to be built within that particular session. And remember, as a mediator, you are in control of that session. So getting parties to be respectful to one another while they're obviously participating is really important. In terms of building trust and in the initial meetings, it's really important that we are not finding ourselves, particularly when we deal with high conflict personalities and conflict, that's rather that we're taking any particular sides who may just drop a side note, and you might acknowledge that and ignite the idea from the other party that you might be taking a particular view. So really understanding what techniques we can use to neutralize some of these comments that may be put forward. In terms of some of the other key things that I'm sure most of you are aware of is really that mutual respect and guidelines. So you may have, like I said, absolutely pleasant clients that might come and see you in the start of the mediation in a very neutral, very humble way. And before you know it, the way obviously that engagement continues, it may arise into being something that obviously becomes high conflict. And then how do we work through that process from obviously there? We do encourage a lot of active listening and where you can emphasize with someone, but be mindful about when you too emphasize on their feelings and concerns, where obviously that may be perceived in a different way from the other party. So again, rephrasing is one of those key things that we would want to make sure that we do, including if we are opening our questions with open-ended questions and what we ask about the exploration stage, knowing when to stop a party from taking things out of context and diverting into other agenda items and dropping between one and the other. So maybe gaining that focus and regaining that control of taking them back to one key issue, making sure that everybody had an opportunity to comment, maybe saying, let's move on to the other agenda items and obviously work from there. Otherwise, if you don't take that control, you might find yourself not really achieving very much valuable out of these particular sessions. So this is one of the key things that I perhaps like to share with you today, and that is the EARS obviously statement, and that is really empathy, attention, and respect. It's really important and imperative in property, obviously mediation particularly, and you might use phrases such as, I can see your frustration with your X, can you tell X how you feel about this? And again, controlling them in that, and then looking at gaining their attention and obviously having their respect and working through these key challenges. Not so much on acknowledging negative emotions and basically not listening to what they're saying and saying thank you for that and moving on to the other. So really making sure that we're acknowledging where we can of what the parties are saying to us. Any type of blaming of others and difficulty of emphasizing, you might want to obviously go into that element and assist those parties in saying, what I have heard from you today is can you tell X what that means for you? And again, that EARS statement is really effective if it's used appropriately. Now, you don't have to use it every single time. It may be something that you identify through body language a lot at times where parties become a little bit impatient with what the other one's saying or wanting to intervene in some way if possible. So again, feeling that connection that they are both present in that room, or whether it's shuttle mediation or one way or the other, is really important without it being obviously in any way threatening to the other person. You find with family law in particular, and I don't know how many of you are family law practitioners or mediators, but really you find that emotions drive. And it's not often that critical analysis of what is at stake that parties infume themselves in. So it's really taking them back to that, why you're here today and why we are taking certain particular actions, what we want to resolve here today. So perhaps implementing that EARS statement is really effective and utilizing that and obviously having that as one of those tools. Now, I've had the pleasure of reading some interesting, amazing books, I must say, and particularly when it deals with high conflict personality traits and how do we obviously manage individuals in that particular space, and setting limits on high conflict behavior is important. So any type of triggering that may be there of defensiveness, such as seeking a party perhaps to apologize, is not a great thing that we'd want to do. So really making sure that we look at the key heart of what we're here today. And the parties may come with the idea that while they're there, they may obviously put the full focus out there that they may also have children, and that may be another cause factor of why they want to have a certain part of that particular property pool or remain in that property without having to sell it. So again, as much as we are acknowledging the past, really we should be focusing on the future and really having those questions on where do we want to go from here and how we're seeing that. A lot of the things that clients will not see is the perception of responsibility and what their responsibility is, and I guess the power of that and what it can do for them. And again, taking them back to the element that they are in control of how they want to find that particular consensus or outcome of their particular mediation today. It is important maybe on a couple of occasions to come back and say that if you are stuck with ABC, and again, rephrasing that for them, what does that mean if you go to court? Do you see that this might get a particular better outcome? So again, focusing them back on that they have a responsibility, but in a positive way is really imperative. Now, I might get a couple of giggles after the next one that I'm going to show you. And this is exactly how it's spelled. The 4, forget about it. And yes, that's how it is spelled, actually. I thought for a minute when I looked at that there is a lot of spelling mistakes, but it's not. And I'll share the resources with you. And really, it emphasizes the things that you must obviously not do. And that is, again, going back of how you deal with parties in that particular mediation and really avoiding any emotional confrontation, more about gaining the insight, controlling that insight that they have and taking them on to the next level of task and what they need to do in order to find and explore those particular proposals, and not really much about how they feel. So they may engage in that, what get them to engage with one another about, because I have to leave the house, I may be feeling A. And because this has happened, I'm in a worse position. And you see the follow-on effect that if you don't take that control and if you don't capture that emotion, that it may just become one of those 4 forget about it situations. And if you can't control it, it certainly will not get any good outcome at the end of that. So again, think about that element of what we don't want to engage in and in what space we are going to find ourselves where we, sit and listen to parties, but really also emphasize about certain things that will not take part in mediation today and what you would like for them to go back and focus. Because think about it once again, it's emotionally driven. Yes, they are there to participate, often some by choice and some because of legalities, and they're required to be there. So having the opportunity to put aside emotions and really focus on the task, because they would have indeed briefed you on some of these things of property pool and their contributions and what they've gone through and where they're at the moment. And sometimes it may be a 5% difference that's brought them to all this conflict. So thinking about whether that small shortfall is going to make a big difference as to what they might reach today, as opposed to if they just walk away and not find any type of agreement. So again, focusing them and getting them to refocus on the target is really important. Again, I'll share with you that particular book that I've read that talks about this, really insightful about really reading the body language of individuals that are participating in obviously these particular mediations. Now, how do we then go back to managing their emotions and making sure that it's effective? So again, create that space where they can ask the questions, where they can obviously express themselves, but also focus on clarifying certain aspects with them while having the other party listen. And it may be that it may take a little bit of time if you send your ground rules of how that is going to work. For those of you that are in mediation and family law, you might see that things don't happen in an hour, not in 2 hours, not in 3 hours, and sometimes they have to take about 5 or 6 or 8 hours. Really making sure that if you feel like that they may need a break, that we take that break and obviously stop at a certain point if we find that it's not getting to anywhere constructive. And it may be that you want to raise that from the very beginning before you engage in that process so that they understand those expectations. You might find a lot of these emotions and might use something that obviously, again, would make you laugh slightly, but a lot of the times you might see parties who start talking about money and property and inheritance and certain things that are on their agenda, and then simply coming on out of that and then raising other concerns about the other person just because the way they look at them and say that they're expressing their emotions in some other ways. Again, just be mindful of how you want to control that. One example I can share with you where a particular client said, so are you laughing at what I've just said? Are you not taking that on board? And again, managing that to some extent is really imperative to get them back to where they want to be, and really acknowledging that they may have been sitting there for a couple of hours already and that they're quite tired and that they have lost that sight of focus. So making sure that we assess as mediators when they need a break and when we take them back to that conversation that is valuable conversation as part of this. Anything non-constructive, we want to make a stop to that rather quicker than letting that take on and engage and immerse in that discussion, and then it may be too late to obviously take them back to that focus itself. So again, summarizing, you might be encouraging certain elements of, if they're talking about inheritance, that you go back to that and that you get both the views, and do they have an agreement? Would they want to obviously consider that as part of one of the key things after you cover their agenda as part of their independent discussions that you have with them and bringing them back to the table, so those particular proposals. Again, it's not a complete list. It's all about really making sure that we identify high conflict personalities rather quicker than letting them have that time and obviously immerse themselves in that dialogue. I have got some obviously resources here that I've obviously like to share with you, particularly obviously, again, make sure that you understand your practice standards, very important, and where we obviously need to draw the line as mediators. The first one of mediating high conflict disputes, I've shared that with you, a really good book to read. They have an audio book and obviously a physical book that you can buy, and that's where I've got that particular tool of how to manage and obviously control parties that are high conflict personalities and traits, I should say. You would also find there is also some other practical skills of preventing and managing some of these personalities coming out and taking charge of the mediation. And again, looking at things that may work for you. You might want to do it from the very beginning and show that authority of how you want them to engage in that, or you might want them to express that view that they have, but also controlling that without obviously becoming outside of their particular agendas that they'd like to discuss. Now, by no means am I claiming to be a complete expert in reading every client, but certainly you get the better of it as you have obviously tools available and identifying parties who start off with the blaming or side notes that they're dropping or simply not paying that particular focus in those particular mediations. Now, that probably brings me closer to the end of this, and I know there's probably a lot more questions, so I do welcome any of your questions and maybe working through them in the time that we have.
It's wonderful, thank you. And I've been dropping in a few of the different resources people have been mentioning as well. There was one about, I read somewhere that the vast majority of property settlements end up being 60-40, give or take 5%. Is that correct? Those dreaded percentages.
And we don't actually have a calculator for these type of things. There is no calculations. It's all, you start off with, and I would not say you don't start off with 50-50. You start off with somewhere where you look at the property pool first, that you have to define what is the property pool, and that you work through that element of 5% or higher or lower. And if we look at 60-40, perhaps that may be in some circumstances where you would have obviously different types of contributions being there, where you see that difference there. It will also be any other factors such as future needs that we have to take into account as part of that. There may be maybe children as part of that, or there may be obviously some other elements that we need to consider. Not to forget, obviously, that it's not always going to be 60-40. You might have sometimes situations where it may be 55-45. It really all depends on the length of the relationship. It depends about the contribution and really spending the time to really take that focus in what they have got so far and how they got to that stage. Not also much more about what has happened in the past and who has done wrong from the other to the other individual. So it necessarily doesn't have to be a perfect formula. It has to be something that sits well with both of them. And if the difference is that they're arguing about 5%, let's say 55 and they want 60, what would that reflect for them if they don't reach that agreement? So it's not necessarily to say that it's always 60-40. You will see some cases where it may be 55 and the balance to the obviously to the other party. So I guess the greater part, and again, Joanne, I welcome your views on this, is often where parties talk about future needs and when they elaborate on that element. And you might see that 5%, even sometimes raised to 15, where it may be pushed up. And I guess you might see that difference in what they agree on.
Yeah, and look, there's a couple of things there, I think. One is just focusing on percentages misses all of the stuff that Arnela's been talking about interests and what people really need and the children and how they're going to be impacted and all of that. But also there is no formula, like you don't get to plug in and out pops, this is the percentage. So we should always be asking people to, what's the range that your lawyer talked about in your particular circumstances?
That's right. And you could talk about the range as a guiding factor as to what is the range that they provided as some advice that they'd be looking at. But remember, by the time parties get to court, that may not be reflective of what they've been advised, because you've got to take into account the element of whether they participated in alternative dispute resolution and whether they obviously engaged in it and how much of that have they already spent.
Yeah.
Because they may have spent a vast majority of what they had, depending on what their financial pool looks like. They may have spent already $150,000 by the time they get to court. And let's say the property pool is rather the minor $500,000 and less. So they're really not left with a lot to work with. So again, taking the focus not on the percentage, but the interest.
Yeah.
What is their interest in that? And what would that look like if they don't find an agreement today?
Yeah.
What would that mean if they go to court? Because again, reinstating that focus that they won't have control. By the time it gets to court, that focus and that control is with the judge who decides perhaps that 5% that they argued about should be to the other party because they voluntarily engaged in that dispute resolution and the other person did not want to, or they perhaps engaged in that, but they were not constructive. They didn't provide full and frank disclosure. So again, legal elements are quite slightly different, but again, getting the focus about that, it's not about the percentage, it's about what is your interest and what would be something that is acceptable to you today without having to spend $200,000. And I'm just being very generous here and saying $200,000 because most cases that end up going to court, we're talking in the range of $100,000 to $200,000 before it gets to the actual trial and having obviously solicitors involved in that process. So the effectiveness of finding that interest and what captures their interest and what they would be satisfied with on today's basis and today's balances is really important, as opposed to saying my interest is 60% because my lawyer has told me. At the same time, lawyers refer back to mediation in order to find that is that 50 or 60%, 5% less, and can we live with that? Is that something that we are able to accept and move on and find that agreement from there? Yeah. There's a lot of case law aside from this where obviously you see parties enter with so much property pool, and by the time they actually go through the court system, they probably have a fraction of what is left.
Yeah.
And you're not finding solutions and something that makes them happy.
That's right. Yeah. So we're talking about a percentage of 30, only 70% of your property pool because 20%'s gone to the lawyers and the legal process.
And you see, that is where obviously taking them back and doing that reality testing as part of the process, whether that 5% will actually be something that is retained by them.
Yeah.
Whether they will lose that 5% plus another 10 because they may not be in control of how long this will take on to go through the court itself. Again, it's about focusing them on the reality of where they are at the moment and what their clear interests are. I've given you an example of the motorbike, and needless to say that it's probably one of the things that I always come back to because it's one of those small things. I have an entitlement of 30%. I have paid ABC money. And the other party would say, no, I have spent more than you in getting that, and really missing the bigger picture of that, of what is my interest in this and how do I conclude this without losing all of it, potentially. So again, getting that focus back to parties of not being emotionally driven, but really task driven and driven by what is in front of them.
Yeah, absolutely. So we've got about 9 minutes left. There's a couple of questions in the chat, and I also wanted to raise the issue of binding financial agreements when things are like a little bit on the extreme end of the court. But the first one was, do you normally have lawyers present? And if so, how do you stop them dominating the discussions? Lawyer management 101.
Oh, that is indeed a very good question. Thank you for that. And I guess while having the lawyers participate, we need to understand what their role is. Their role is not to give advice on finding solutions. Their role is there to advise the clients on their legal standing. And that is where they're obviously needing advice about whether that is something that is acceptable and what their options are. But at the same time, controlling lawyers, and they can often be very dominant, depending who you have in the room, is really taking them back to say that this mediation is about A and B. And while you are there and present, and you may give your client advice, and throughout the break, you might advise your client, is really just to make sure that the focus is not on the solicitor being present, but only on the client itself, and really making sure that they understand these ground rules and abide by them. You might have solicitors, quite a lot more than not, who simply do their own way and to obviously engage in that, and really making sure that we put a stop to that very quickly. And we might go back to some of the rephrasing of that and saying that while we appreciate you being available for your clients as part of this mediation, the role of this is today, or the role of this particular mediation is on the client to explore these options with the other party. So they remain silent. They don't have a way of obviously contributing and adding their element in there. And if you find someone that is very disruptive, you may want to obviously put a stop very quickly, and you might want to even at times ask them to leave. It may be necessary. It really comes down to what the demeanor is of that person. I've not come across someone as that of yet, but I have heard of colleagues where they had to do that very quickly, where the lawyers think they're in the courtroom and they can simply objection. I'd like to add something to this and add their feel to that, and really making sure that we put them back on reality testing. It's not about you, it's about your client. So again, that's one of the things that you want to do. So lawyer one-on-one, this is not about you. You can be a shining star outside of this, but not today. You're here to support your clients when it comes to the mediator saying you might want to get some advice from your legal advisor about ABC. Whether that is a binding financial agreement, whether that is drafting orders and what impact there may have been in terms of the legal impact thereafter, can they be amended, and those type of things, but really not allowing them to drive that particular mediation itself. And some lawyers are better at that and others not so much when it comes to obviously not engaging in finding that solution for someone. And that's why it takes a bit of, I guess, different work to be a mediator as opposed to as a solicitor.
Yeah, absolutely. And as you said, a little bit of preparation can really make a big difference if you help them to know what happens in your room, in your place, because that's where they're being invited in rather than, the court or somewhere else.
Oh, absolutely. And look, my experience with many of the solicitors, they do understand the process and what is part of that. But then you also have practitioners who engage in that process with the idea that I understand how it's going to work, but I'm going to be here to support you, and bringing out that obviously that charisma in themselves, that they would want to take charge of that situation at times. And again, that's where we obviously need to find that communication of stopping that rather quicker than letting them take the drive of that. And it may be that sometimes you might have a solicitor who is simply wanting to influence the way the client is going to speak to the other party. And again, making sure that we control that from early on, and that we have them only participate when it's necessary for them to do that.
Absolutely. So there's another question. How do you like to deal with contributions in a small pool, which can be really difficult? An example would be young couple, recently married, bought a house, landscaping, lots of gifts and money going in. It's not worth what they've put in. You can't get it out.
Oh, absolutely. And I guess one of the key things that you would want to focus on is what do they have, and what is something that they obviously have contributed on both sides, and working with that, as opposed to, I guess we know the pool is $500,000 and less. And again, working with that on the idea that you have A, B, C, and there may be only 2 agenda items. So maybe we put all the money to the property improvements of that, and that's all we have, but we can't find who has contributed more or less. And I guess working with that in a way that we make them aware that it's a smaller property pool and what they are working with, as opposed to something that would be necessary to go through litigation. So looking at the highlights, whether it's their contribution, taking them through that aspect of who has contributed what, closing that agenda, and then moving on to the financial aspects. And the last perhaps one would be about the future. It may be with smaller property pools that you would want them obviously to engage in rather that solution, or I guess proposal finding rather quicker, as opposed to having the even solicitors involved in that aspect. I don't see many solicitors being involved. They usually are told to, or I guess suggested to go to mediation rather quicker. So working with them in a way that is constructive, and that they obviously understand both the interest and where they're standing off with that particular dollar figure that they're working with.
Yeah, and it's often much harder when it's a small, because there's not enough to go around. And so, no, it's easier if there's a few million and people can be reasonably okay.
Oh, absolutely. And it's a good point that you raised. When it's such a small property pool, then you really have to gain the momentum of the focus of what is that interest that you have now. And it may not be something that obviously will take you hours and hours to go through and get their participation in acknowledging that. So you might, within a couple of 2 or 3 hours, get to the bottom of that, of what their interests are, and having them to really find an agreement between themselves, as opposed to, as you said, where there's a couple of millions, you might find that it's going to take a lot longer to get to the exploration stage and the options that they want to obviously generate from there. Capturing what is that contribution and knowing where they obviously identify that on both ends is really imperative.
Yeah, but lots and lots of reality testing. You can't.
Indeed, a lot of reality testing.
Yeah, look, wonderful. We're right on time. There was a final question about how do you deal with one person bringing a lawyer or a support person and the other not. So trying to manage that, balancing the room. If you wanted to very quickly.
Okay, absolutely. And I guess, again, the focus should be if someone is bringing obviously a support person, making sure that the other person knows that they may want to obviously have someone present, and really reiterating the role of that person so that they are not going to make decisions, that they're not going to engage in any dialogue. And again, making sure that person does not have any type of active involvement, more so to be present. So it's sometimes just emotional support of feeling the need that they have someone next to them. So really making sure that is well articulated between the two of them and that it's obviously acceptable. They might want to come back the other party, get someone else as a support person.
Yeah. And sometimes you might decide on shuttle because it's going to affect. So ultimately it's up to us.
Certainly you might find that if there is that power imbalance, I might refer to that. And if you have two on one side and one on the other side, you might say shuttle may be a better appropriate way to obviously work through that.
Yeah, no, that's wonderful. Look, so much information, and everyone's like, oh, can I have a look at the recording or the thing so I can go back over again?
Well, if you do have any questions, you'll be able to reach out to me. On the slides towards the end, you have my contact details. But look, it is an interesting area to be in, and certainly one that takes a lot of commitment in exploring and identifying parties. And needless to say that really when we are dealing with obviously family law, parties, emotion is what drives things as opposed to the reality. And that, Joanne, you identified it perfectly on the spot. Reality testing every couple of times, making sure they come back to the square of what they're working with.
Absolutely. And you're probably aware there's another Family Law Act amendment bill in the pipeline that's going to be looking at property, which is probably going to make our job a lot harder because it's looking to incorporate the impact of family violence in a more.
Indeed. And that certainly probably would be another session thinking about how do we then manage that as practitioners.
Yeah.
And how do we identify this, and when do we know when to draw the line of risk, and how do we identify risk? So I think a lot more needs to be taking place about educating on that, being trauma informed, and how do we identify parties that are at risk.
Definitely, absolutely. And Rowanna's dropped the events link into the chat, so you've got what's coming up. And some of the questions that people have asked are great for supervision as well. So group supervision, really good opportunities to workshop some of the things that you've raised. So thank you so much.
Thank you all for coming today. I really hope that you got to enjoy this, and something for you to think about, obviously, when you engage in that mediation, because it doesn't always have to be litigation on the other side.
Yeah, absolutely. Thank you.
Thank you once again. Have a lovely afternoon.